This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about why a dispute over the extent of damage to a residence is not bad faith, and why evidence of unreasonable conduct is required to obtain bad faith damages. In a case where repair versus replace was found to not be a tort because there was a reasonable dispute over the extent of damage, a case entitled Michael Gerstman and Marie Webster versus Crestbrook Insurance Company, the United States District Court for the Northern District of Texas on June 9, 2025, found that Michael Gerstman and Marie Webster sued Crestbrook Insurance Company over a storm damage insurance coverage dispute. The court proceedings included various claims related to breach of contract and violations of Texas insurance law. Following Crestbrook's denial of the plaintiff's claim for damages caused by a hail and windstorm, the plaintiff's property in Dallas was insured under a policy issued by Crestbrook. A storm caused significant damage to the property, prompting the plaintiffs to file a claim. An initial inspection by Crestbrook's associate estimated damages at $6,061.68, which was below the plaintiff's $25,000 deductible, leading to a denial of the claim. Subsequently, the plaintiffs hired a public adjuster who estimated the repair costs at $137,545.19, including a full roof replacement, prompting Crestbrook to reinspect the property and increase its damage estimate to $10,093.45, still falling short of the deductible. Crestbrook sought to strike the testimony of plaintiffs' experts, Dr. Neil Hall and Kevin Funch, arguing their opinions were irrelevant and unreliable. However, the court ruled that Dr. Hall's testimony regarding the cause and extent of the damage was relevant and based on sufficient experience and methodology. The court also found that Funch's estimates were relevant to the claims being made by the plaintiffs. Crestbrook filed for summary judgment on several claims, asserting that the plaintiffs could not prove their damages exceeded the deductible. Thus, Crestbrook was not liable under the policy. The trial court found there was a genuine issue of fact regarding whether the damages exceeded the deductible, particularly in light of the differing estimates provided by the plaintiffs and Crestbrook. Without taking a position on whether one or the other was more accurate, Crestbrook also sought summary judgment on claims under the Texas Prompt Payment of Claims Act and other violations of the Texas Insurance Code. The court determined there was sufficient evidence to suggest that Crestbrook may have wrongfully denied or delayed payment, thus denying Crestbrook's motion for summary judgment on these claims as well. The plaintiffs asserted claims for common law bad faith and violation of the Texas Deceptive Trade Practices Act. The court noted that a bona fide dispute regarding coverage precludes liability for bad faith claims, and since the court found genuine disputes regarding the breach of contract claim, Crestbrook could not obtain summary judgment on these extra contractual claims. However, the court did grant summary judgment on the common law duty of good faith claim, as the plaintiffs failed to provide sufficient evidence of unreasonable conduct by Crestbrook. The court ultimately denied Crestbrook's motions to strike the expert opinions and granted in part and denied in part Crestbrook's motion for summary judgment. The ruling allowed the breach of contract and TPPCA claims to proceed while dismissing certain extra contractual claims. The focus of a bad faith inquiry is the reasonableness of the insurer's conduct in rejecting or delaying payment of the claim. An insurer breaches the duty of good faith if it denies a claim when its liability has become reasonably clear. Moreover, an insurer cannot escape liability by failing to investigate a claim so that it can contend the liability was never reasonably clear. It breaches the duty of good faith and fair dealing by failing reasonably to investigate a claim. A bona fide dispute regarding insurance coverage precludes liability for breach of the duty of good faith and fair dealing and violations of the DTPA and Texas Insurance Code because plaintiffs have failed to present evidence that would enable a reasonable jury to find in their favor on the claims of breach of the duty of good faith and fair dealing. The court granted Crestbrook's motion for summary judgment as to those claims. Insofar as plaintiffs have failed to produce evidence to support their remaining DTPA claims and have not suggested that any of these other claims is not based on the same theory underlying the bad faith claim, the court granted summary judgment for Crestbrook on the remaining DTPA claims. In my opinion, in the late 1960s, when I was a trainee adjuster, the Supreme Court of California created a new tort called the tort of insurance bad faith. The tort has since spread across the United States. It has been adopted in many states, including Texas, but the tort can be defeated if the insurer can establish a bona fide dispute. The insurer had a good faith dispute with the insured as to the extent of loss and its experts. The bad faith tort was dismissed, but the claim will still go to trial. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,050 blog postings. If you view these videos, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com, and you can subscribe to the videos. They're free. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publication for a very small fee. Thank you for your attention.